Bill's meeting for February 28th, 2019 to order. Would you please rise with me? Oh, wait a minute. First, it's call to order. Would you please rise with me as we pledge allegiance to the flag?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. May we have a roll call, please?
Chairman Taylor.
Here.
Vice Chairman Shahab.
Here.
Member Smith Rodriguez.
Here.
Member Johnson. Alternate Member Kilpatrick.
Here.
All right. We do have 4 members here, so we can go forward. Do we wait till we call the agenda item to talk about the 4, or do it now?
Why don't you go ahead with the minutes?
Go ahead in minutes. All right. Okay, looking at the approval of minutes from November 28th, 2018, all the way last year. Did anybody see any corrections or additions that need to be made to the minutes?
No.
May I have a motion?
I'll move to approve the minutes.
Second.
All right, it's move in a second. All those in favor, say aye.
Aye.
Any opposed? Very good. All right. This time I get to give a little speech. All right. All persons who anticipate speaking on any public hearing item must fill out an oath card to be heard on the agenda item and sign the oath contained thereon. These cards are located on the table over to the side by the entrance to the council chamber, or may be obtained from the recording secretary. This meeting will be conducted in accordance with the procedures adopted in Resolution 24-1997. Those speaking in favor of a request will be heard first, those opposed will be heard second, and those who wish to make a public comment on an item will speak third. The applicant may make a brief rebuttal if necessary. A representative from either side, for or against, may cross-examine a witness. Anyone who speaks is considered a witness. If you have photographs, sketches, or documents that you desire for the commission to consider, they must be submitted into evidence and will be retained by the city. Please submit such exhibits to the recording secretary. And staff, has the item been properly advertised before us tonight?
Yes, it has.
All right. Do we have any members that have visited or spoken to any members of the public regarding items on tonight's agenda?
No.
No.
All right. I need to know from me also. We have no consent agenda. We have no old business. We do have one item up for new business. And before we do that, I will ask council to speak to the applicants.
Thank you, Chair. I'd like to address the quorum section of the BAA's bylaws, which provides the following information for your consideration. For the purpose of transacting business at any regular meeting, adjourned, special, or called meeting, 4 members shall constitute a quorum, and an affirmative vote of 4 members shall be required to pass on any matter, except that an affirmative vote of 3 members shall suffice to pass on a motion to deny a request for a variance. This is a 5-member board. 4 members are present. 4 members are required to conduct business. 4 members are here tonight. 4 members are capable of conducting the business. The applicant has the opportunity right now to say that she wishes to delay this until the next meeting, if that is the case, to have the opportunity to have 5 members decide on this variance. If the applicant wants to do that, she should get up at the podium and tell me one way or another what her wish is for this application at this time.
I will waive the wait. I'll go with the 4 members.
Okay.
I think that should suffice.
Would you state your name and address for the record,
Robin
please?
Taylor, 4997 River Edge Drive, Titusville.
Thank you, Ms. Taylor.
Thank you. In that case, we will go to the, sorry, I have to scroll down. First item on the agenda tonight, which is variance number 1-2019- for the address of 4997 River Edge Drive. So staff, would you lead us into this, please?
So the application before you tonight is for a variance request into a rear yard setback. The staff report starts on page 12 of your packet. Okay, so the applicant, Ms. Robin Taylor, is requesting a variance to the following sections of the code to allow a balcony encroachment into the rear yard setback for property that is located at 4997 River Edge Drive and with a zoning district of multifamily high density R3. The sections this is requesting a variance to are to sections 28-307C. The section states that there should be a 25-foot rear yard setback for a principal structure. The other section she's requesting a variance to is to 30-151D to allow allowance for a 5-foot encroachment into a rear yard setback for elevated decks or balconies on townhomes toward the water where property is adjacent to a water body or common area. So the property is, as I stated, on River Edge Drive in the Hidden Cove subdivision, Hidden Cove townhomes, rather. The future land use, the comprehensive plan future land use designation is high-density residential. Again, the zoning is R3, multifamily. The surrounding zoning, as we looked at around the development, not just the property. On the north side, it's got a shoreline mixed-use zoning. South of the development, there is an open space and recreation, OR zoning. East of the development is the Indian River Lagoon, and west of the development, across the street, is a property that has a zoning of regional commercial. So I'm on page 13 of your packet. The lot does not meet the minimum width and size of the R3 zoning district for a townhome. The R3 requires a 20-foot wide lot in a townhome development, and the lot is only 16 feet. The R3 also requires 2,000 square feet of lot size, and currently the lot itself is 1,280. And that's just this townhome development. Each of those units have fee simple lots. So that's what each one of those lots is supposed to be, a minimum of 20 feet wide and 2,000 square feet. Further down on that same page, page 13 of your packet, I'll just briefly describe the powers of the board. That the board will consider the following criteria: that there are special conditions and circumstances which exist or which are peculiar to the land, structure, or building involved, that are not applicable to other land, structures, or buildings in the same zoning. That there are special conditions and circumstances that do not result from the actions of the applicant. Granting the variance requested will not confer upon the applicant any special privilege that is denied by others. The literal interpretation of the provisions of the ordinance would deprive the applicant of rights commonly enjoyed by others. The variance granted is the minimum necessary in order to meet the intent of the code. Granting of the variance will preserve the spirit of the ordinance, remain in harmony with its general purpose and intent. And granting the variance, public safety and welfare will be assured. The last criteria, in no case shall the granting of a variance result in a change of use, which would not be permitted in that zoning. That's not an issue here. So further down to the bottom of page 13 of your packet, I'll briefly describe the analysis. The applicant, again, is requesting a variance to the rear yard setback. We've measured that the variance request is about 15.9 feet to allow a 9.1 foot rear yard setback remaining. A balcony, according to the city's definition of accessory buildings and accessory building, accessory structure, a balcony is considered not an accessory structure. It's actually attached to the structure, so it's part of the principal structure. So it would have to meet the principal structure setbacks. That's what the issue is here. A porch would be considered differently. An attached screen porch is attached to the building, but is exempt from the principal structure setbacks. It can meet an accessory structure setback, a much more flexible setback. So that's the issue here. There is a porch on the back of the unit that was added, I believe, in 2015 or 2016, per a variance that was granted by this board a couple of years ago, to allow the footprint of the building itself on that lot to exceed the maximum 50% that was allowed in that zoning district. And so a variance allowed them to be able to add that first floor porch. But a second request for variance that was from a few years ago was not approved and did not allow them to add the second floor and third floor balcony to the back of the building, because that would be considered part of the principal structure. And that's similar to the issue here. I'll read the definition of accessory structures. An accessory building, an accessory structure is a subordinate, detached, emphasis added, building or structure, the use of which is incidental to that of the principal building on the same lot or parcel. So again, a balcony or deck is considered to be part of the principal structure. The applicant previously enclosed the existing balconies on this unit. I'm going to show you an image that were provided to us by the applicant of what the existing structure looked like and how it was originally developed. The townhomes developed back in the 1980s and included a back porch, first floor porch, plus a second and third floor deck. The applicant several years ago enclosed those spaces, but did not expand beyond the actual building footprint that was originally developed back in the 1980s. And that was based on an interpretation of the building official at that time. They could do that without actually increasing a nonconformity. They're just building within that same envelope. So they just enclosed those decks basically with walls and made it an air-conditioned space. Then subsequent to that, they asked for a variance to allow for an additional deck and balcony to be added to the back. And so that's what was originally denied, and that's what's being asked for here based on a new ordinance that the city adopted. I'll explain it in a moment. The addition will encroach, as I've already mentioned, if approved tonight, 15.9 feet into the required 25-foot setback, leaving a new setback of 9.1 feet. The staff recommends denial due to the fact that the existing balconies currently encroach into the setback. The staff could not identify a hardship to warrant adding new balconies that will further encroach into the setback. The code discourages further encroachments by stating the following. According to section 34-345 of the code, non-conforming structures, extensions, enlargement, or expansion. It states, a structure not in conformance with these code regulations shall not be extended, enlarged, or expanded where such activity will result in a greater nonconformity with respect to such standards as setback, height, lot coverage, or density. So what I did in the rest of the report here on page 14, I tried to address each of the criteria that I've already described. Special conditions and circumstances which exist that are peculiar to this situation. The staff believe that there are no special conditions or circumstances which are peculiar to the structure or building involved in regards to the setback variance request. There are special conditions and circumstances do not result from the actions of the applicant. The applicant enclosed their existing balconies and desires to add new ones. The non-conforming size and width of the lot does not result from the actions of the applicant, however. Granting the variance requested would not confer upon the applicant any special privilege that is denied by others. The applicant enclosed their existing balconies and desires to add new ones. The recently adopted ordinance, 53-218. So last year, the city adopted a brand new ordinance that allows a property owner in a townhome development that is that wants to put in a deck or a balcony to allow them to encroach, allow that new addition to be attached to the back of the unit to encroach 5 feet into the rear yard setback. So again, a maximum of 5 feet toward the water where property is adjacent to a major water body or common area. Later on, I did attach the entire ordinance for your reference here. I'll refer to it in a moment. The request tonight is for a balcony on a townhouse that is adjacent to a common area. However, the principal structure currently encroaches into the rear yard setback already. In addition, section 34-345, which I've just read earlier, of the code discourages increasing non-conforming structures from encroaching the required setbacks. So that's where staff is on that issue, is that the code discourages additional encroachments due to not allowing more increasing of nonconformities. On the next criteria, the literal interpretation of the provisions of the ordinance would deprive the applicant of rights commonly enjoyed by others. It is staff's opinion that the interpretation of the ordinance would not deprive the applicant of rights commonly enjoyed by others in the same zoning district and in the same geographic area. So on page 15 of your packet, number 5, the variance granted is the minimum variance that will make possible the reasonable use of the land. And so I just referred you back to my responses to criteria 1 through 3. On number 6, the granting of the variance will preserve the spirit of the ordinance and remain in harmony with its general purpose and intent. So our response was that a rear yard setback of 9.1 feet remaining, if approved tonight, is a significant reduction from the existing 17.1 feet. The building coverage request maintains the intent of the ordinance. In addition, the code states a structure not in conformance with these code, as I've already mentioned, shall not be extended, enlarged, or expanded where such activity would result in a greater nonconformity. On number 7, the granting of variance, the public safety and welfare must be assured. Staff does not believe that the welfare and safety of the public is at risk if this is approved. And I've already addressed the use issue. So our recommendation is that staff recommends, our recommendation is that the request be denied for the following reason. The structure is not conformance with the regulations, shall not be extended, enlarged, or expanded where such activity would result in a greater nonconformity with respect to such standards as setback, height, lot coverage, or density. So on page 16 starts the application. And on page 18, the applicant's reasoning for the request starts there. On page 19 is an illustration of the rear facade of the building. And you can see on page 20, under the roof line, there was a porch and a second floor and a third floor balcony that was constructed with the original footprint of the development of the buildings. And then those were, in this particular instance for this property, those spaces were enclosed, and now the applicant is asking for an addition on the back. And you can see that in the illustration on page 20. On page 22 is a survey that was provided to us with the first variance from a few years ago. We've reused it here with the request that the applicant has requested us to do because it illustrates what they're trying to do. You see in blue, that is that was the footprint of the existing porch and decks that were enclosed. And in red is the location of the recently approved and developed first floor porch. And so that same footprint where you see in red would be where the second and third floor deck would be located if this variance tonight, request is approved tonight. And you can see that illustrated again on page 23 of your packet in that survey there. Okay. On page 24 of your packet is an aerial. Unfortunately, the property appraiser's information online, their parcel lines don't really jive with the actual walls of each unit, so it's kind of offset. But you can see where we tried to use their online tool to see where the rear of this development would be, of this unit would be in relation to the water line. And the water line is actually further down, but we measured from the top of the rocks, the rivetmen, to the back of the property and believe that they are outside of the shoreline setback, which is a whole nother setback in our code. So we do not believe there was an issue there. As you can see on page 25 of your packet, there's an aerial that kind of, we did a very cursory analysis as to which units would probably be questionable as to whether they would encroach into the rear yard setback and also the shoreline overlay waterfront setback. On page 26, you'll see some photographs of the rear of these structures that were provided to us by the applicant. On page 27, you'll see the unit circled. That is the applicant's unit. And if I'm incorrect, I'll ask Ms. Taylor to correct me on that. And again, on page 28, is the back of the unit. And I believe she'll have to correct me if that's the current, if that is a current picture. Okay. Okay. On page 32, this was an exhibit that was provided to us by the applicant a few years ago with the first variance, and with her permission, she asked us to, well, actually, I suggested that she provide this to you in order to illustrate her argument based on her reasoning that was in her application. So this was something that was provided to us to show which unit has an addition that was added to it and which ones do not, based on the information provided by the applicant. This is not something that was staff generated. On page 33, again, that is an exhibit that was provided by the applicant. This was not generated by the staff. And on page 34, you'll see another exhibit showing the location of the existing, of the original footprint of the location of the porch and the second and third floor balconies that were enclosed. And then on page 35, this illustrates what is being added, ultimately, if this is approved. Okay, so again on page 36 is another survey illustrating the conditions and the request. It looks like some things were copied, duplicated here. Okay, now on page 43 of your packet, I included sections of the code for your reference. So section 28-307 is the code that is written currently. So there was an ordinance that was adopted last year. It had not been codified into this code section. So I'm going to refer you to that in a moment. The next section on page 47 of your packet, section 28-391. Again, this has to do with the setbacks of a detached accessory structure or the setbacks of an attached screen porch. On page 49 of your packet, I've included the development order that was issued to the applicant back in 2015, telling them about the denial of the second variance. And that is referring to their original request back in 2015 to encroach the rear yard setback with an added deck. The reason they're able to ask for this tonight is because of this ordinance starting on page 50 of your packet. The City Council was asked to look into the ability to give property owners relief from the code in order to allow them to add a deck to the back of their units. The City Council approved this ordinance in November of 2018, and it states the changes that included are to page 51 of your packet. You'll see a cell there or a square there in the code section about the setbacks. And under this part there, it talks about rear yard setback. It says 25 feet, and it has a notation 1 and a notation 2. And those notations refer you to another bottom part of that page that refer to townhomes developments shall have minimum distance between, let me see. It says notation number 2, which starts in the top of page 52, excuse me. For townhome developments, see section 30-151 projections. So that refers us to another section that was adopted by council. And if you go to page 54 of your packet, you'll see subparagraph D. And that's what's being requested, variance is being requested to this section here. It states, within any townhome development adjacent to the Indian River Lagoon and located in the R3 zoning district, elevated decks or balconies, excluding screen rooms or other enclosures on townhouses may project into the rear yard setback a minimum of 5 feet toward the water where the property is adjacent to a major water body or a common area. Open stairs, fire escapes, and chimneys on townhouses may project no more than 4 feet into the required side or rear setback. Principal structures, including balconies, may not extend into the shoreline protection setback required by Section 30-63 shoreline protection setbacks. So the applicant is requesting an ability to a variance to this ordinance that was adopted in 2018 to allow them to have an attached balcony to encroach 5 feet into the rear yard setback. Well, the issue is that the existing structure already encroaches into that rear yard setback, and the applicant is asking for a variance to go beyond that maximum 5 feet. That ends my presentation on this. I'll try and answer any questions you have, and Ms. Taylor, the applicant, is also here to answer any questions.
Staff, all right, I'm calling first floor ground level. So there is a balcony that was built on the second level. Is that correct? Is that what we're seeing? There's a deck, porch, whatever you want to call it, on the second level at this time.
What was permitted was a first floor porch, screened-in porch, and they have a roof on top of that.
All right, but it has rails around it.
There is nothing that I could find, that the building official could find, that prohibits someone from putting railing on top of a roof.
Okay. Okay. So that was allowed then? Okay.
Yes, sir.
So now we're wanting to go to the third floor with a, I guess we're calling it a deck this time? Or are we calling it a roof on the second floor?
The request specifically is for a balcony.
Okay. All right, so that means you can stand on it, and it'll have rails too. All right. Other questions of staff?
On page 34, and also then 35, but on page 34, is that what the structure is today? I mean, the handwritten notes point to the second and third floor balconies, the arrow with a balcony. Currently solid, both sides, privacy wall. I think the arrow is pointing there.
That is the current, yes. The existing porch and second and third floor deck space that was originally constructed with the development were enclosed. And that's what this is illustrating on page 34.
Okay, so then, I don't know which page it was. Somewhere in the 20s. Are they enclosed right now, as in like air-conditioned room?
I'm going to ask.
I can ask the applicant.
Okay, yeah, I think Ms. Taylor could probably answer that best.
Okay, I'll wait.
Thank you.
Are there other questions of staff before we move on to the applicant? All right, seeing none, we'll open it up to the public at this time, and the applicant will please come up first. Again, stating your name and address for the record, please.
Robin Taylor, 4997 River Edge Drive, Titusville. Sounds so ominous. I've worked on this for quite a few years, and I wouldn't pursue this if I didn't believe that I was justified in asking for this, especially when it's already been done. Numerous times, several times in our own development, other areas. And I do believe there's a hardship because the original property had to have no more than a 10-foot setback. There is one unit on the property that the original setback was only like 8 feet. Also, looking at the current setbacks on the plan, if you can refer to don't know if I can find it. Well, you know, I won't be able to find it. Okay, I've got it here for your copy. Just take your copy. If you look at the current code and the setbacks for detached buildings, screen porches, swimming pools, pool enclosures, detached building structures, attached screen porches, swimming pool, pool enclosures, this is kind of a little bit of redundancy, but there's nothing over 13 feet. We do have an existing balcony that was approved, and I know that staff calls it a roof. It does have railings, and all I'm asking for is another deck above that that's not extending beyond where I'm already at. There are also, like I said, structures. The one that you were asking about, I'm sorry, Ms. Rodriguez, the one form was, I believe it was 34 that you were asking about?
On page 34, but then I also found the other picture I was looking at, which was page 27.
Okay, this should be in your packet. This is the existing. This is page 19. It's kind of, I guess that's kind of out of order, but this is what it actually looks like right now. Okay? So then what I'm asking for is directly above it, showing a balcony on the 3rd floor. Okay? Now there are several, and this is basically the same thing, just showing this is what I have, this is what I'm asking for above it. It's already there. There are units in the complex that were permitted, no variance, and I would have to research the code at the time, but there are units, I will give these to you. I make copies. This one, the gentleman is rebuilding his current decks, his decks, because they were decaying. But if you look at the setback, he's got like 5 feet. I'm sorry. He has 5 feet from his border that his decks are on. So he, you know, there is one mistake in staff's numbers. It says 9.1. That is on one corner. On the opposite corner, it is 10.4 feet. So it's, you know, it's diagonal. So that's going to show. So that would still be within the original setback when the property was built. However, after the balconies are built, I will still be, according to the maps that staff has, is 33 feet from the shoreline, even after the balconies are built. So, and there's another 2 units that extended. They're 5 feet from their border. They extended, enclosed their original balconies, made new balconies, and have existing balconies. And the balconies are 10 feet. And you should have these in. Maybe you don't have these. I'll give you these. The one with the 5-foot setback and an 8-foot setback in the back. These all have a 10-foot setback. I have a unit here that has a 5-foot setback. It was an addition on the side, but it still only has a 5-foot setback. There's another unit that was permitted, no variance, and built a garage on the side. And if you look at the survey, the corner of the property is actually over their property line. They've gone into the easement. They are up on their property line with no setback whatsoever. This was approved. And with that addition, they invaded one of the units' direct view of the river. I'm not going to be affecting anybody's direct view, and I have both of my neighbors on each side of me, one on one side, one on the other. They have no problem with it. And they can speak that. Then you've got units that are built. These are several properties. This is Segrin's. They are actually built over the water, whereas I'm going to have a 33-foot setback from the water, even after my decks are built. Then you have Shiloh's, which is the restaurant. We all know how close that is to the water. Then you have River Landings, and this was built in 2003. And was that allowed to build over the rocks? Actually over the rocks onto the water? And these are built in 2005. This is the Rio Vista. They have setback of 10 feet, but these are all units that have been able to, look at how they're over the water. I believe there are special conditions. We've worked really hard to bring Hidden Cove into conformity, and the only way we can see from my position being on the board is to allow the enclosure of the 8-foot balconies and add an 8-foot balcony on the back if the boundaries permit. There is also a very huge safety factor. On the second floor, the kitchen is at the bottom of the steps going up to the third floor. If there were a fire in the kitchen, there would be no way to come down those steps and past the kitchen. You would have to go out. A balcony would certainly suffice in giving us a safety factor. I guess I fail to understand in the analysis it states that the balcony is not defined as an accessory structure. It is defined as an accessory building, accessory structure. I really don't see the difference, but with all the other setbacks that are all within like 10 feet, and I'm only going over where I'm already at with the current balcony that I have, I really don't understand. I mean, I truly believe that I'm not asking for anything more than anybody else has done and what I already have. Thank you for your consideration.
Don't go anywhere yet.
Okay.
May I? Yes, please, go ahead. So, do you have the packet in front of you on page 27?
Yes. I don't have my glasses.
It should be a picture of I think it's your unit. It says my unit 4997 at circled.
Is it the back?
Yes,
Okay.
I think that's it.
Yeah.
So were you granted a variance to put the first floor
I didn't need a
porch-
variance.
I'm not fighting with you. I'm asking you a very simple question. Were you granted a variance for that?
You're just hearing my frustration. I did not need a variance at all for that. It only
Okay.
required a 10-foot setback
Okay.
for that balcony, for that
So-
porch.
What is above that were the space that the structure, the part of the townhouse house that I see, was that at all open space at one point in time, enclosed?
There were two balconies, original balconies, they were enclosed,
Okay.
which the city was allowing. And then we got the porch that only requires a 10-foot setback. I don't understand it's in the
Well,
the
I'll
doc-
tell you
the
what
ord-
my concern is. My concern is that there's a slippery slope. So if those two balconies that you're describing, that there were balconies there and they were at some point in time enclosed, did you need to get a variance to enclose them?
Yes. No, I didn't. No, I didn't. I
Okay.
did not need a variance to enclose those.
Okay. So you've enclosed it, so you had a balcony there
Yes.
and you liked having the balcony there at
Yes.
some point because you want it again. But you've enclosed the balcony that you had. Why
Right.
did you enclose the balcony that you had and now you're seeking just another balcony?
It was already, like I said, there are several units that were already done that did this with no variance, with no,
Well, I understand, but if you want a balcony, why did you enclose the balcony that, sir, behind, I really need you to stop shaking your head. I got it. You want to come up and speak, you can speak, but you're distracting me while I'm trying to get these questions asked. If you wanted a balcony, why did you enclose the balcony that you had?
because we had the understanding that we would be able to add balconies on. I mean, we were told by the HOA when I bought there at the time, and like I said, while I lived there, I mean, I should have done it when I moved in, but it was done prior and after I moved in.
Because the slippery slope is, if you have the balcony, if the variance is granted today, and the balcony is permitted, and later on you decide, well, I'm gonna get another variance to enclose my balcony, as I've previously done, because the testimony here is, well, people have already done this, I've already done this. So what prevents you from continuing to enclose and build, enclose and build?
Because that's what we're trying to do at the HOA for the majority of the people that are there. They want to enclose the original 8-foot balconies and add an 8-foot balconies, and that would be our maximum. We can change our documents to represent that.
I have a quick question for you. The HOA approved actually what you're doing?
Mm-hmm.
All the HOA is already in approval?
It's approved, the modification request is approved by the board,
By the board?
but
And
they felt that they couldn't deny it because it's already been done.
Who, the board, you mean?
Yes,
The HOA board?
yes.
And why can't the HOA board come in for everybody, modify everybody's plan, instead of everyone coming in with their changes?
Yeah, we tried to do that, and I don't even recall what the outcome of that was. I don't recall what the outcome of that was. We tried to get a blanket. It said we had to require rezoning or something.
Several years ago, there was an attempt to ask the city council for a blanket or a change to the zoning district that would allow them that flexibility for all those units. But the ramification of it was that would impact every property that had the same zoning district throughout the city. And so staff recommended to not go down that route. And so city council did not address that at that time.
And if, there is no other set of townhouses that begin to have the setback that we have. My unit probably sticks out the most at this point. The ones that have already been modified can't go any further. So this is why I'm asking this.
Well, I'm looking at the picture from 27, and I'm looking at the balcony right next door. And why can't they enclose it or build a balcony on top of that? They can extend to the water's edge or the 10-foot setback and build on top of that, and then keep going up. And then the next one will do the same thing. My feeling is, this is a building. It's one building. It's not two buildings. And each one should be consistent all the way through.
Right.
So whatever they do, it should be a homeowners association decision that they want to go through it, and then they come in for a total change to the zoning, or a variance for the whole thing, not to just for each one would come in, like the next homeowner
So you
comes in.
apply for a blanket variance? Is that what you're saying?
I'm not saying blanket variance. I'm saying just come in for a change to the whole setup of the document of the condominium, and basically allowing the condominium to increase 10 feet or 15 feet into the setback, or whatever you're asking for. But you can't have every single one of the homeowners come in separately and ask, can I add 5 feet? Can I add 4 feet? And all of a sudden, it becomes like a mishmash, between all the units.
Well,
And that's my concern. My concern is, you can't go into a structure and actually start changing the structure. This whole thing was built at one time.
Yes. And they've been modified.
That's my concern. If you start modifying, you add 4 feet, somebody else wants to add 5 feet, so, it becomes a problem.
And then you have another hardship where there's probably half the lots in there. I think it's in one of the pictures. There's 20 units that are advantaged because they do have the they've already done what I've done, or their property is long enough where they won't even need a variance. So then that leaves 12 units that are disadvantaged that do not have the setbacks due to the original date that it was built and the original setback requirements.
Okay, I don't have any more questions.
Any other questions? Ms. Witness? All right, thank you very much.
Thank you.
Thank you very much. Our next witness, please.
Chuck Hermanson.
Welcome, sir. If you give your name and address for the record, please.
Chuck Hermanson, 4969 River Edge Drive.
Okay.
I'm pretty much here also just on behalf of Robin, and like you said, there's other 4 or 5 other ones that were already done years ago. I've been there 10 years, and ours already was closed in, and they didn't replace our deck at all. We have no decks, and I'd love to have our 8-foot deck on either second and third, but that's what we're just trying to get her through right now, and if it'll work, or do, like you said, a whole community thing. I'm for anything. I just want it all to look how it's supposed to look. You know, they all looked at a certain way at a certain time, and now they're all different. You go in there, and they're all different. And the way hers would be with a deck on each floor, which both her neighbors are right here with her, they also want to build out and put a deck on. And it would all start to look the same again. But right now, it doesn't look the same at all. But I would also, if you do consider doing this, I want to get my decks also, because we have no other way out of our house but through a burning fire in the kitchen. So we would appreciate you, thinking about what you're going to do here and helping us out too,
Which address are you?
4969.
49.
I have plenty of setback to do. I don't have river right behind me.
Oh, okay.
She's
Oh,
just
there
up
you
where
are.
the river curves, and then my house is starting back where it curves.
Okay. 4969, okay. Are there any other questions for this witness or comments?
I just want to tell you that this is my concern, is everyone comes in and actually adds things to their lot. Like you have a plenty of setback, you might want to increase your building,
Not if it's in your
the square
documents that
footage.
we put for our
I understand.
HOA.
But, sometimes, if you have the setback requirement, and you can take that unit and increase the square footage of the unit.
Sure you
And
can.
this is a whole building. See, we are taking part of the building and changing it.
It's been
That's
done
a
for 10
major
years.
change,
There's
yeah.
people here that have done, he did his back there, it's been done. And his neighbor, and his neighbor's neighbor. 3 of them on the very
It's
end
amazing,
building's
yeah.
done.
Okay.
They all bumped out, made their decks right on the water. They're on the water. They are 8 feet between the water and their building. So she has 35 feet roughly. I have 100 yards. I got a football field. But some of them just don't have it. But the problem is that somebody back in the day said, go ahead and do it. And they did it.
Absolutely.
And now it's done.
Yeah. Thank you.
Thank you.
Thank you. Next witness, please.
Stu Buchanan.
Good evening. My name is Stuart Buchanan. I live at 5015 River Edge Drive. As I'm in part of this development, I apologize for distracting you earlier. I have spent the last 24 years as a city or county planner. I am not here tonight in that capacity. I'm here tonight as a resident. When this complex was designed, a civil engineer, an architect, a landscape architect were all involved in designing it. And that's the way how it looks the way that it does. And then the city of Titusville got involved. The first thing that happened was your building official issued an interpretation, as your city planner just stated, saying that you could enclose your balconies. That was the beginning of the downward slide. The people that enclosed those balconies, when doing so, they created their own hardship that you've heard tonight about fire hazards. They created it on themselves. And the other people purchased those units with the balconies enclosed. That was because of your building official's interpretation letter. Because it was an interpretation letter, no notice was required to any of the other unit owners. The next thing that happened was the owner came before this board because now you're enclosed. I don't have a balcony. Well, we can all see where this is going to lead. So they came before the Board of Adjustments and got a variance to go out. Then they came and requested the staff to do a text amendment, which infected the entire city in the R3 district. Because it was a text amendment, as your staff will tell you, no individual notices were required to go out because it affected the entire zoning district. If notices would have gone out and we would have known how this was going to affect Hidden Cove, the homeowners would have showed up and spoken against it. But again, because it was done as a text amendment, even though it only applied, it was being written for a single unit, no notice was given. And the city was following its own code in doing so. Perfectly understandable. Now we have our next variance. So they received a permit to put in a first floor deck. Then they put a roof over it. Then they put a balcony on it. And now they're in front of you again for another variance. Every time the city of Titusville gives a little, it goes one step further. First, your building official issued the interpretation letter. Then you gave the variance. Then you did the text amendment. Now you're back for another variance. The reason that the homeowners association has come in here to ask, as the one board member requested, we don't want it. We didn't want the balconies enclosed in the first place. Your staff has recommended denial. I would encourage you to follow your staff's recommendation. I am uncertain why material was allowed to be presented for properties that aren't here. They have nothing to do with this. The handouts that you saw of other properties that have built closer over the river, that has nothing to do with this case. I would also encourage you, when you look at these other units that have built out, they're not facing to the south. They're facing a different direction. They have different setbacks. It's a completely different set of rules. Front, yard, side, river edge. You all know this. You served on this board. Again, I would encourage you to recommend denial. Go along with what your city staff has recommended. They're absolutely correct. I'll be happy to answer any questions that you have.
I have a quick question for you. Does the homeowners association have some kind of a responsibility to the looks of the building?
Yes.
And how about, do they have funds that they generate from the homeowners?
Very little, because there's only 32 units.
So, but there is no maintenance per se of any of the units?
No, they're platted townhouses, not condos. So each unit owner is responsible for their own.
So it could look, somebody can paint it black, somebody wants to paint it white, whatever he wants.
Actually, I believe there's an architectural conformity clause when it comes to the colors.
See, what I'm looking at in the picture, that's 27, if you want to take a look at it. I mean, it's like the way it's put together. You can see the planks, the way it's put, the columns. It looks like different than the next one. So each one unit, if they get the variance, then they have to do it. They might do it differently then.
Yes, as one of your members stated earlier, this is a slippery slope. Every time the city of Titusville grants another variance, grants another approval, grants another interpretation, does another text amendment, just erodes the community one step further.
Okay, thank you.
Thank you.
Do we have any other?
Richard Gaudio?
Thank you for allowing me to speak on this variance. My name is Richard Gaudio. I've lived in Titusville since '67 and at Hidden Cove since '83. I've owned 5001, which is 2 homes east of the applicant's home, since '95. Having lived in Hidden Cove since it was built, I think that this application for variance is the biggest threat we've ever seen. The second-story porch at 4997 is very different from other additions in our community because it is causing large negative impacts to neighbors. It was built after being denied by this board. Since it has been allowed to stand, a similar non-conforming porch was built on the adjacent home to the east at 4999, which is adjacent to my home at 5001. Most impacted is the adjacent home to the west at 4995 because it's offset 6 feet to the north. For years during construction and after, the owners asked our city to do something about the denied porch which blocked their view. They even kept the curtains closed to the view because occupants of the denied porch could look back into their living room. They finally gave up and sold the home, which now has one of the worst views in the community. I own the second most impacted home at 5001. It's on the east end of the building and is offset 6 feet to the south. The as-built offset used to give a feeling of seclusion on the 5001 south porches that was comparable to living in a detached home. You didn't see any nearby structure, and you rarely heard anybody talking. Anyone who's lived in attached housing knows the value of this as-built offset. The added non-conforming porch at 4999 consumed the 6-foot offset plus 2 feet more. Occupants of the 4999 porch can now look back into the 5001 living room. The 5001 as-built privacy, which was among the best in the community, has been taken. If this variance is approved, this board will be ruling on many more, choosing winners and losers as the build-out in front of your neighbor additions spread to the west. When the western homes have finished their additions, a new variance near the east end may start it all over again. After all, if we don't stop this now, why should we expect it to be stopped in the future? It's true that a variance is not required for additions to some homes. If our community is too short-sighted to see where this is headed, then we'll deserve the resulting conflict and loss of property value. Please help us avoid this by denying this variance. I made 4 pages. It's very confusing actually figuring out what's happened here. There's a lot of conflicting statements. These 4 sheets at the end are a model I made to show you the history of exactly what's happened to the 4 homes on the east end of this building of 10 homes. Everyone's forgotten, but this is what it looked like when it was built, the page 1 of 4. You can see the 6-foot offsets, the privacy walls, the second and third story balconies. You can see the direction of north. They face almost due south, and the view is to the southeast. So if anybody to the west of you extends to the south, it blocks your view, blocks your breeze, causes their sounds to come into your house, their smells from their barbecue. You know, it's... So the first thing that 4997 did is the next page, page 2 of 4. In yellow there, they added the roof and they enclosed the second and third stories. If you go to page 3, you can see the added denied porch on the second story. And in particular, the line there that says view back into 4995 living room, it's really quite absurd. If you go out there and look at it, you won't believe that anybody would allow this sort of thing to be built at all. Well, and they didn't. It was denied. And the last page shows the current configuration, where the 4999 built a non-conforming porch that's exactly the same as the one next door. And now they can look back into 5001, which is my home, there on the end. So I hope that you will consider these negative impacts to us and deny this variance.
Just to be sure I'm understanding, to enclose that porch, they had to extend the original roof line out. Is that correct?
Yeah, the roof is an absolute disaster. They chose a slope that intersects my roof at 5001 at a very shallow angle there where the 2 gables meet. And it's a disaster. It's now leaking, and it would require a very expensive large piece of flashing that they didn't build. And anyway, yeah, required a roof. They had 3 choices of roofs that had already been built in the community. One of them started at, if you wanted to put a roof over your porch, there's 3 other types of roofs that have already been done. The best one starts under the existing eave, only goes out 8 feet. In order to get headroom per code, you got to drop the upper porch 6 inches to do it. But that's the best one. It looks the best, and it works the best, and has the least impact to your neighbor. The next one is, we had a home that burned up, and they had to replace the trusses. And when they did, they made 2 pitches on each side of the roof. They started the porch roof basically back at the ridge, and they ran it all the way to the eave of the porch. And then we have another one that raised the ridge of the roof so that the slopes on both sides were the same, but then it still would come down and meet the new eave of the porch roof. So they had those 3 choices, any one of which would have matched something that was already there, and they did this, the 4th choice. I tried to talk him out of it, but I wasn't able to talk him out of anything.
Any other questions of this witness? Thank you, sir. Or do we have anyone else to speak?
Ann Rimbert.
Okay. Thank you.
Good evening. My name is Ann Rimbert, and I'm here tonight to support the staff's denial of this variance. I'm a 3rd-generation Brevard County resident. I grew up in Rockledge, but have lived in Titusville at Hidden Cove for more than 30 years. After reviewing Ms. Taylor's application for variance in the R3 zoning code with the recent revision, I believe this variance should be denied for the following. The property is not adjacent to common ground or a waterfront. It is adjacent to a 20-foot deeded property that belongs to the Florida Department of Transportation. This is specifically not a part of the Hidden Cove plat. The Hidden Cove is an odd thing because it's a subdivision of single-family attached townhomes. We all individually own lots. It's also unusual because the subdivision is split in half by this 20-foot tract of land that belongs to the DOT. There's a historic drainage ditch that used to flow through there. And it's unusual to have a subdivision that's not contiguous, you know, that's split like that. We're here tonight because it doesn't, it's not adjacent to common ground, so that's part of why she's here for a variance. The 2015 request for this variance was denied by the BAA. There is a 30-day appeal available that Ms. Taylor did not pursue. She asked to go up 2 and 3 floors with her porches at that time, and she was denied. In an attempt to mislead, she submitted with her application an altered survey with the Florida Department of Transportation property line whited out to make her rear yard appear to be adjacent to common ground. See this on page 32 of your application. Now, listening to Brad tonight, I can say that perhaps that wasn't necessarily her intent. Perhaps they asked her to do that to make her argument. But again, that piece of property that abuts hers to the rear, it's not even a part of our subdivision. Yes, we can walk on it. Yes, we mow it, but still not a part. The 2015 BAA meeting was well attended by neighbors in opposition. The BAA responded to the intrusion of privacy concerns the neighbors expressed at the time with a denial of a 2nd and 3rd floor porch extension. Her current use of the 2nd floor patio roof as a porch is a direct affront to the direction of this board's denial in 2015. Please see her pictures of 2nd floor porch in your application package, page 29. I can tell you that when originally they built their downstairs patio with the roof on top, it took a few months and then we saw the handrails were made. The handrails went up and then they went down. And then they went up and they went down. And we watched this over the year or so, and then they went up and they stayed. We knew that would happen. She chose to enclose her porch to add space to her living and bedroom. She chose it. She had porches there, as most of us do. Yes, some people enclose their porches. only a few of the units have extended out with another porch, but I'm not convinced that everybody doesn't want to do that, has been represented this way this evening. That's just not the case. Her covered patio is what made the rear yard non-conforming, not the fact that she no longer has porches. The amended change to the R3 language will allow some of our neighbors on the far west of the property a 5-foot encroachment without variance because they are adjacent to common ground. This is unfortunate. If porch extensions are built on these properties, extended privacy walls will follow, which will further limit the view and decrease the property value. The extended wall, you'll have to come in. If you do that, if your neighbor does this and then you have to do it, now you've got to build another privacy wall that extends out, or else your neighbor's going to be able to walk out onto their balcony, which is what Robin's can do now, and look back into the living room or into the bedroom. So, I mean, that's just, it's unfortunate. Please, we hope that you'll assist us by once again denying this variance for second and third floor balconies, porches. Thank you.
Are there any questions of this witness? Thank you very much.
Mr. Chairman, I would like to make a clarification on some of the testimony that was given on just now. The letter that was given to you.
Yes.
States here that Ms. Taylor, back in 2015, had a 30-day appeal available. I think that's in reference to why she's asking for this variance today. Well, again, it's because there's a new ordinance that she's asking a variance to. So it's not a repeat of what was originally submitted back in 2015. I just want to make that clear. And then there's a second statement here about the Florida Department of Transportation property line being whited out. This is in reference, I believe, to an exhibit, page 32 of your packet. That exhibit was originally given to us several years ago with the original variance back in 2015. And when I spoke with Ms. Taylor, I'm talking about what she could do as far as submitting an application and what her rights are as far as submitting her request. I did point out to her this information that was provided to us before that she could use towards her application. So she chose this particular exhibit, among others, to be resubmitted with this particular application. So I don't know if if that area was whited out or that area was just not copied correctly. But yes, there is a Florida Department Transportation right-of-way. I think it's a drainage right-of-way that runs right through the middle of this subdivision. And so it's actually excluded from the actual official plat. That is correct.
Chairman, can I ask a question?
Oh, yes, please.
Just the setback that we're talking about, it's not from the DOT, it's from their property line, right?
That's correct.
Okay.
Okay. What page again was that, the new ordinance on, please, sir?
You can find it on page 54 of your agenda packet.
54, all right. And that's what we're ruling on tonight, is that correct?
The new ordinance is on page 50 of your packet.
50.
That's where it starts. But I believe, yeah, I'm sorry, City Attorney is referring you to the specific section of the code that is relevant here, and that's on page 54,
All right.
subparagraph D.
Okay, and earlier you stated this already goes into how many feet of the setback? 6 or 7 feet or 9 feet? What was that?
Excuse me. On the staff report,
Yeah, I'm sorry, I'm getting a little confused, there's a lot of pages.
I understand. On the staff report, let's see. That if approved tonight, there would be a remaining variance, or remaining setback for the principal structure of 9.1 feet out of the required 25. That's for the balcony and deck, because remember, that's, if it's attached to the structure, it's considered part of the principal structure. The porch was a whole nother animal. That is just, the code specifically excludes an attached screen porch from the principal structure setbacks. It actually says that it just has a different setback requirement. So as Ms. Taylor testified, it only requires a 10-foot setback for the attached screen porch.
Okay.
And I'm sorry, that Ms. Taylor also mentioned it on the survey, that there is a greater setback on another side of the property. Page 23 of your survey, I'm sorry, of your packet rather, you'll see a survey there.
Yes.
And yes, the back property line does run at an angle, parallel to the, it's not an exact parallel, not exactly parallel with the rear of the building. So we measured it from the shortest distance, not the longest distance side of the lot.
Are there any other questions of staff on this point? Did we have any other cards to be heard, please?
No, sir.
All right. Is there a rebuttal from the witness? From the applicant, I'm sorry.
Yeah, I'm a little shocked myself because there's some untruths there. The porch was permitted and approved and signed off by the city. So it was not built illegally. As far as 4995, she said that they're on the other side, that they were set back, that they couldn't have any privacy. They never lived there. They never lived there one night the whole time I was there. The neighbor that owns it now has no problem, and she's affected more than anybody. And she has no problem with me building the balcony. So that's a very erroneous response that they stated. And as far as looking back on the units, I have another picture here. Maybe I pulled it out already. Oh, I just had it in my hand. Here it is. This is showing.
We have it.
This is showing what we're trying to accomplish in Hidden Cove and have both balconies with railings. All four of these units look back on each other into the units, and there's numerous other ones that look back on each other. And that's, I understand that this will probably not pass, but, and I will deal with that later. But the majority of the people, I had 8 or 10 people here at the one meeting a few months ago. There's a lot of people in support of this. The few that are not in support of this are very few. And I would like you to approve it, obviously, but I understand your questions and I understand your concerns. And I will continue to work on this.
Was the roof permitted?
Yes.
As part of the open porch?
And my unit and Craig Reinick's unit are the only roofs that...
Just asking about yours.
Right, but I just want to make a statement that those are the only 2 roofs that were built according to the way the city wanted them built. They're the only 2 buildings that were roofs that were extended that were permitted the way that the city would like to have them built.
Any other questions of the applicant? Thank you very much. All right, at this time, we will close the public hearing and bring it back to the board. Are there any further questions of staff that anyone would have to address? Okay. Then I will entertain a motion. Or is there any other discussion among ourselves?
I move to deny variance 1-2019 on the basis of A, B, and C, actually. There are no special conditions or circumstances peculiar to the land. The special conditions and circumstances that were suggested by the applicant are due to her own actions, and the variance being granted would confer special benefit.
All right, I have a motion. Do I have a second?
I second.
Okay. Is there any further discussion? All right. May we have roll call, please?
Chairman Taylor,
Yes.
Vice Chairman Shahab,
Yes to deny, yes.
Member Smith Rodriguez,
Yes.
alternate member Kilpatrick.
Yes.
All right. So the motion for denial has been approved, so it did not go through. All right. Yeah. What is next? Do I have anything next? What do I close with? Oh, I can't get there. How do you go through these things faster? There we go. Okay, last thing I see here is the annual report that's submitted to City Council, is that correct? And our semi-annual report, which shows a whopping 4 decisions that were actually decided on. Is there
We work
anything-
hard with our applicants.
Okay, so there were 4 things that were being sent to the City Council. Did they approve it, or it's just entered in the record?
It's for your reference.
It's just for our reference that it was being sent, or has it already been sent?
I believe this was already provided to the city council. If this, back in December or January.
Excuse me,
we would have already
Brian.
provided. No, it has not.
It has not, no. They have to approve it here first, and then it goes to council for final.
I stand
Yes.
corrected. Excuse
Thank
me.
you.
All right, so we see the semi-annual report. May I have a motion to approve the report?
Before you make a motion,
Oh,
I
yes.
have just one comment about it. I believe the reason why we bring these to you before we bring it to city council is we ask for your input if this is appropriate information, or if you have any other additional information you'd like to have included, provided to city council. This is your communication to them, including specific requests that you might have.
All right, does anybody see anything on these 4 items that need clarification or additions to what is on the written report?
I mean, the only thing that might be useful on the ones that are denied is to include why it was denied. I mean, perhaps, I don't know. And I suppose also for anything that was withdrawn, if that was because staff was able to work with the applicant and get something done, it might be smart to notate that as well.
We can do that. if
That may
that's-
be much more complicated than a simple statement to be included on that report. So I would agree that the basis for denial, because it's part of the motion, is a good recommendation, but I would hesitate to say to recommend the detailed reason for the withdrawal.
I could see that get lengthy if it was a long discussion. All right, do we need to vote about why it was denied? I mean, to add verbiage for denials?
I would welcome a motion at this time to recommend approval of the report with the additional details of basis for denial.
All right. Do we have such a motion?
Yeah, I'll take care of that. I move to accept the the semi-annual report with the condition of including the reason for denial of any variance.
All right. I have a motion. Do I have a second?
I'll second it.
All right. Is there any further discussion?
No.
All right, roll call, please.
Member Smith Rodriguez,
Yes.
alternate member Kilpatrick,
Yes.
Chairman Taylor,
Yes?
Vice Chairman Shahab.
Yes.
All right. And that will go before city council at the next meeting or a month?
Yes,
after?
sir.
It will go before the next meeting. Okay. All right. Get back to the beginning. How do you jump all the way to the back, the front?
Hit in the page number 1, what's up?
Click on it? Oh, okay. Hey, that's that neat.
Then hit enter.
Oh, hit enter. Here we go, Dean. Ah, okay. Thank you. At this time, do we have any petitions? Well, I missed this earlier. Petitions or requests from the public. Do you have anything further to say before I make a comment? Very good, sir. Your choice to come up.
Good
Again,
evening. My
please
name is
state-
Stuart Buchanan, 5015 River Edge Drive. I do have a request or petition, or perhaps staff could provide direction. The prior interpretation by the building official allowing these porches to be enclosed, what would be the actions necessary to have the current building official or to appeal that interpretation, to have the current building official review that and see whether it was correct? Now that we have evidence here on tape with people saying it's created fire hazards, it's created fire enclosure problems and escape problems, what is the procedure to go forward to have that original building interpretation, which began this slippery slope, changed?
I believe that would be a meeting with city staff. If
We can certainly provide you the letter and have a discussion about alternatives.
And the reason I asked is some cities, to appeal a decision, interpretation by the building official, it goes before Board of Adjustments. I'm not sure how the city code is written.
Appeals of administrative interpretations do come before you.
There we go. Then I'll be seeing you again. Thank you.
All right. All right. Any other requests to speak? All right. Any reports from staff?
No, sir.
Council? Do we have anything on the books at this moment for next month?
No, we do not have another application yet.
All right. Anything from the members?
No.
Just to remind the public, we do still have 2 vacancies on this board. One is an alternate, which is open to anyone. And again, the other position is a specific that Counselor would be happy to enlighten you on if you just want to make a phone call and ask about that. So, seeing no other business going on, I'll rule this meeting be adjourned. Thank you.
Thank you.